Swayam Prabha. Digital India. Educated India.
Dear students, this is the time to study about a new school of jurisprudence that is called Natural Law School of Jurisprudence. I am Professor Anupam Jha, and today we will try to understand this new school of jurisprudence. Particularly, we will try to understand Professor Lon Fuller's and Stamler's views on this natural law school. In this lecture, we will try to understand about the modern founders of this school and what was the legal philosophy of natural school. And then we will move on to look at the 8 principles of legality as propounded by Professor Lon Fuller. Then we will move on to see the case of Speluncean explorers and how that was relevant to understand natural law jurisprudence. Thereafter, we will also see that what were the views of another philosopher of this school whose name was Stamler, and then finally we will evaluate this natural law school. First of all, we will try to understand about Lon Fuller's life and personality. Lon Fuller was born in the 20th century and he died in 1978, and he was a prominent American legal philosopher, and he had also a scholarship in the field of contract law. He was a person who was born in Texas of America. Texas is a state, and there in that state he received both his undergraduate as well as law degrees, and then he moved to Stanford University, and you see that he had a teaching career, and he started teaching at Duke University and finally at one of the most reputed universities of the world, that is Harvard University. At Harvard, he also held the prestigious chair of which is known as Carter Chair of Jurisprudence until his retirement in 1972. So, he retired at the age of 70, although there is no age of retirement in US, but still he took a decision to retire at the age of 70, but till then he had made lot of contribution in the field of this jurisprudence and also in the field of contract law. Fuller's central contribution lies in his theory of jurisprudence, particularly his concept of procedural natural law, that we will try to understand today, and in that way he challenged the views of law as simply those set of rules which are imposed by the authority. His ideas continued to be relevant in evaluating the quality of legal systems worldwide. So, in this way what you can understand that this person's, Lon Fuller's personality had a great influence in the whole development of jurisprudence in the modern times. You see that one person can also influence the system, one person can also contribute to the whole branch of knowledge. This is the personality of Lon Fuller, who himself individually contributed to the scholarship of this field of jurisprudence. He was renowned for his contributions as a person who gave something to jurisprudence, and not only that, but also he was a practicing advocate. He practiced in Boston law firm when he was in Harvard. Boston is a city, and in Boston there was a law firm, and he also practiced there in consultancy with that law firm. So, he had a great personality. Now, we will try to understand his legal philosophy because he was a person who belonged to natural law school. Students, natural law school has a very long tradition. Natural law school was not born with Lon Fuller. Natural law school has a history of thousands of years. The moment person arrives in this world, person is born with natural rights, and what we now call human rights, those are also the natural rights. So, the civilization's origin, when the human civilization started, then from that time onwards, the natural law and the natural law philosophy that was there. But at that moment of time, it was the influence of religion. It was the time when different religions were there in the whole world. Even today we have different religions, but that time the influence of religions on the natural law school, that was too much, and that is what these scholars like Lon Fuller, like Stamler, they wanted to dissociate religion from the law and the knowledge of science of law, that is jurisprudence, and there he made a mark. He said that we have to dissociate religion with the law. Although he belonged to the same school, he belonged to natural law school, but then he said that we have to be different. Natural law school has to be different, and he wanted to focus in a different way. So, students, you might not confuse that natural law school, whether that was founded by Lon Fuller. The answer is no. Natural law school has a long history, and even in the modern times, natural law was not only started by Lon Fuller, but take for example Grotius. You might have heard about the famous scholar, the famous philosopher in the legal field, whose name was Hugo Grotius. Hugo Grotius was also belonging to natural law school, although many scholars they say that he belonged to a school which is midway between positivism and naturalism. But you know, many scholars they also say that Grotius, because he had written a book named Law in the Times of War and Peace. So, war, whether war is better or peace is better. Now, this is a very common question, very simple question, and perhaps you might also know the answer. The answer will be that every time peace is better. Now, from where this peace has come to your mind? It is the human mind. It is the mind which is rational. Whenever you think that what is more rational, whether war is better or peace is better, you will find that peace is better, because your mind, your rational mind will say that in peace you can develop yourself. When you are in peace, you can think about yourself and about the members of the society and about your nation. But when your peace is disturbed, when your mind is not in peace, then you cannot think in the right direction. So, Grotius had written at that moment of time in the 18th century the law on war and peace. So, he also belonged to the natural law school. He also said that war is not right. Even during the times of war, there should be rules to regulate the conduct of the warriors, of the combatants. And thereafter, Hugo Grotius was made a famous scholar, and he had made many contributions in the law of the sea also, where he had propounded the theory of what we say that freedom of the oceans. And he said that oceans should be free, because that was made by the nature, and therefore oceans are free for all the nations of the world. And then the whole course of international trade, maritime inter-exchange, that was possible, because what he said that there should be no control of one particular nation in the sea. So, Grotius made a lot of contribution in the field of natural law, and he is also considered as the father of international law. So, what I was telling you, that whenever you think of war and peace, whenever you think of development, when you think of our climate, where these things have come from, you will have to say that these are coming from the natural law school. Natural law school always focuses upon those rules which come from every human's mind, which is coming from the rational mind and rational minds of every human being, whether a person is born in India, whether a person is born in America. They may have some common platform where they have the agreement that no, peace is better. A person of America will not say that war is better. A person in India will never say that war is better. So, we have the common platform. War is not better, peace is better. Who will say that development is not better? Who will say that human rights are not good? Human rights, where from human rights have come? Human rights have come from the minds that no, life is important. Who has given us life? Life has been given by the God. So, students, what I wanted to tell you, that the basic rights which have come from the nature, from the rational mind of the human being, they are all common, and therefore, the laws which are made on the basis of natural law, they are universal in nature. We had in the earlier lectures, we had seen about the positivist school. They discarded the natural law school. We had also seen in the historical school, they also discarded the natural law school. But natural law school, there are places when you say the human rights, whether human rights should not be protected, whether international law should not come into the picture, when the human rights of one particular group of community of a particular nation that have been violated. In such case, if international law will not come to rescue, then even sometimes you might have heard that the human rights of the citizens of a country is taken away by the leaders of the country also. So, we have to understand that human rights are important. We have to understand that human rights need to be protected. So, natural law school made a great contribution. Now, in that line of approach, we have also to understand Lon Fuller's contribution in the field of natural law school. Just I wanted to make you aware that Lon Fuller is not the only scholar in the field who propounded the natural law school, but there has been a line of scholars in even the western countries. I am not talking about our own region. In our country also, there has been a long tradition of natural law givers, and in some other lecture we will talk about those times. Yagvalkya Smriti we had Manu Smriti in those times. So, we have also these were natural law givers, and they also were a combination of positivists and the natural law givers. So, we will discuss about these things, but right now what I am telling you, that Lon Fuller, whose contribution in the modern times, in 20th century, how he gave a new direction, that we want to know today. Now, Fuller's central contribution lied in his theory of jurisprudence, particularly the concept of procedural natural law. Now, there have been many scholars in the field of natural law, but in the field of procedural natural law, perhaps he was one of the great contributors. He challenged the view that law is simply a set of rules which are imposed by the authority. You remember the Augustinian philosophy? You remember the Hart's philosophy, that laws are made by some superior authority. Laws are made by a person in authority. Law is made when the superior power has delegated the powers to other authorities. But what Fuller says, that I am rejecting this view, and what I am saying, that law is not always given, and law not every time is given by the king or by the PM or by one particular group of persons. but law sometimes is also deriving its authority from nature. And then he went upon to give 3-4 things about his theory. What he said? There has to be inner morality of law. Law should not be whatever the lawmakers wishes to make laws, but laws must have inner morality also. Now you see, many scholars have discarded the role of morality in law, but he was a scholar, he was the person who said that not only that there is a relationship, but we should say that law should have inner morality in it. What did he mean? He argued that a true legal system needs an inner morality, meaning thereby it should follow those principles like fairness, like predictability, like clarity. So, fairness, now how the law can be fair? Law can be fair, he will say that okay, what are the principles of fairness, that we will see also just in some span of time. But what he was trying to tell, it is not sufficient just to make laws, but it is more important that law should also be fair. Then he says about 8 principles of legality. He said those 8 principles constitute inner morality of law, and he emphasized aspects like clear communication of laws, possibility of compliance, and consistency between pronouncements and actions. These were some of the principles which are important. We will see about the 8 principles of legality, what he said. And he disagreed with positivist views that law is solely a sovereign's command. He believed that the degree of inherent morality strengthens a legal system. If the legal system does not have inner morality, the legal system will not endure for a very long time. It needs to have inner morality. And that is the twist that he gave in the natural law. He said that while I acknowledge the connection between law and morality, he distanced himself from traditional natural law theories that relied upon pre-existing universal moral codes. So, he gave this twist in the natural law, and therefore, today I am giving little bit more focus upon Lon Fuller's contribution to this school of jurisprudence. Now, students, let us try to understand the 8 principles of legality, and those are the law of morality. What are those 8 principles? You might have heard about the eightfold theory of Gautam Buddha. You see, likewise, this is the 8 principles of legality which are called law of morality. First is generality. Laws must be general, and it must specify rule which prohibit certain kinds of behavior, or law must specify which actions are, which behaviors are permitted. Then the next is promulgation. Laws must be widely promulgated. It should not be secretive. Law must not be made in a secret room, and then if someone says that okay, was there a law or not, and then on the basis of that secrecy the person must be punished. It should not be there. There should be fairness in lawmaking. The moment law is made, it should be communicated, it should be promulgated. The public needs to know, the public needs to be able to access the laws which are made by the parliament or which are declared by the judges. So, the public wants to know, the public has the right to know. Clarity, non-contradiction. Law should be clear, law should not be unclear. Law should be understandable. If I will not understand law, how will I fully appreciate what I am going to do and what will be the consequences? And law should be free from contradictions. If I make the law in a way that in another line there will be contradiction from with the meaning of in the first line, whether that will make a good law? It will not be a good law. So, natural law comes where you say that law can be good and law can not be that good, relativity, or sometimes you can say there is a law but it is not fair. Now, that is also one of the thing. So, this natural law school tries to understand that aspect, whether the fairness of law is there, whether the law was promulgated before or not. And then the next is prospectivity, whether laws are prospective in nature or retroactive. Now, retroactivity is not natural. The lawyers and the legislators, the judges, they should not declare or they make the laws that law will be retroactively applied. Law should always be applied in the prospective time, and it should not prescribe that individual's future behavior that will be predicted upon the law which was not passed at that time. So, prospectivity is very important. Possibility of compliance, the law must not ask for the impossible to follow. If the law will be made that never speak the false, always speak the truth, it will be sometimes difficult, and therefore, this should not be the law that always speak the truth. Stability and non-arbitrary change. Laws must remain constant. If law will be changing every day, what will happen? Will there be order or will there be anarchy? So, to have a good legal system, we have to have a stability of law, and there should not be arbitrary change in the legal system. Always the change should follow the reasonable process. Without the reasonable process, there should not be change in the law. And then congruence between official action and pronouncements. There needs to be a congruence between what the written statute declares and how officials enforce those statutes. So, if the officials will look beyond the statute, that will not be right. So, right and wrong, this is about natural law. What is right, what is wrong, and that is the point where the human minds come into picture. Human mind can say that this is right. As a student, you might understand that what is right, what is wrong. This is natural, and from there natural law derives its authority. Effectiveness, finally he says law should be effective in achieving the stated goals. A law that fails to achieve its goal is useless. So, now these are the eightfold principles of legality, eightfold principles of morality, and Lon Fuller said that these principles of morality must always be known, must always be there in any legal order, so that this will be good. Now, once you understand these important contributions of Lon Fuller, some of the recent real life examples may be there. You see that there is a Right to Information Act, and this Right to Information Act, this is about what? Accessing the knowledge, accessing the information. You do not pass anything in your office which is secretive in nature. If you are in a public office, what you have to do? You have to take a decision which is in the interest of public, and if the public wants to know, you have to share the information. This is about the Right to Information Act, and you see that this is about generality, this is about promulgation, this is about effectiveness. So, this promotes transparency. Transparency is a natural thing. Every human being mind says that there should be transparency. How a person takes any decision, how does a person punish another person? Now, there needs to be if there will be transparency, people will not be angry. If there will not be transparency, then people will be angry and the laws will not be effectively adhered to by. Next example may be the Dowry Prohibition Act. You see that there exists the law there is the promulgation of law, but where is the effectiveness? So, promulgation of law is one aspect of effectiveness, but analysis suggests that if you give stricter penalties or if there will be improved implementation mechanisms, then only dowry prohibition, this law can be more effective. So, promulgation is not the only thing. Legislators can promulgate any laws, but if it is not effective, and how will it be effective? There has to be inner morality of law. If inner morality of law is there, law will be definitely more effective. So, we have seen some of these examples, we will see some more examples. Let us go to the next slide. We will see that what are the debates which surround Fuller's theory. Now, the 8 principles that he gave, like possibility of compliance, like effectiveness, these are open to interpretation, and it can be sometimes difficult to know that okay, what is the, how much the compliance is there. So, there is no such measurement technique by which you can say that the compliance can be measured and what is the possibility of compliance, whether on that basis you can decide that whether laws are effective or not. Cultural specificity. Fuller's principles might be culturally specific and not universally applicable. Legal systems across the world have different goals and priorities. What constitutes a good legal system might vary depending on the context. So, this is also one of the criticisms that have been levelled on Lon Fuller's understanding. Next is lack of emphasis on substance. Fuller's focus was on procedural fairness, which overshadowed the importance of substantive justice. A law might follow all his principles, but still be unjust in its outcome. For example, a discriminatory law could be clear and well communicated, but sometimes it violates fundamental rights. So, many scholars, they try to give criticisms, and this is one of the valid criticism, that there is a but he had a focus on different thing. He did not focus upon the substantive part of the law, he focused upon the procedural part of the law, and then only he was so famous. Next was that difficulty in evaluating existing legal systems. When you apply the Fuller's principle to analyze existing legal system, that can be cumbersome and that is not very practical. Real world legal systems are complex and may not always perfectly embody all 8 principles. So, these are the criticisms, but as far as the substance of his philosophy remains, the substance of his philosophy stands still very important, and it is important that how his contribution was different, in a different way, because I told you that there have been so many scholars in the field of natural law school, but this person whose name was Lon Fuller, his contribution was in a different way. Procedural fairness, procedural how the law can be procedurally more reasoned, more fair, and that is where he stood differently. Now, while trying to explain his natural law philosophy, apart from the 8 principles of legality and then procedural fairness, he also wrote a very famous article, and there he imagined something. That was a imagined case, imagined dispute, imagined story, but that imagined story that had many lessons to learn. And let us try to understand that story. That is called as Speluncean explorer's case. And students, we will try to understand this, and then we will try to understand that how this case gives us so many pointers that how natural law school can be appreciated, can be understood in a very different or simple way. Now, look at the facts of this case. Then only you will understand that how complex. It was a simple case where there were some explorers. There were 5 explorers, and they were the members of a society named as Splensian Society. And those explorers, as you all know, that explorers go to new places to explore the unexplored. And what they did, they were just a member of amateur society. They were not professionals even. So, it was an amateur society of people who just took interest, and they have been happy that they went somewhere to explore some new places. So, what one day what happened, that 5 of these explorers, they went to explore, and where they went to a mountainous region, and they entered into a cave. And what happened, that once they entered inside the cave and went inside for some distance, then there was a landslide. And after the landslide, the entry point of the cave, that was closed. They were trapped inside the cave itself, and the cave was very long. They could try to find out another exit point, they could not find, and in the landslide even the cave was broken somewhere, it was not possible to look at other side. So, they were just trapped inside. You might have heard the recent story of a cave in the state of Uttarakhand in this year itself. But such stories, such imagined story, that imagination was of Lon Fuller, when he had imagined that these explorers were going inside the cave and landslide came and they were trapped. And what happened, that they had taken some food along with them, but when there was a landslide, they could not come outside, because they had initially planned that okay, we will go in the weekend and come back on Monday and we will join the duties. But what happened, they were trapped, and the limited food they had, that was also going to expire. So, 3 days, 4 days, 5 days, 6 days, 7 days, and likewise days were going on, and they were just having some piece of food, and just so that their life will be saved. But there was a time when they found that okay, I had a radio also, radio device. So, what one person did, that with that radio they wanted to communicate to the outer world, and they flashed the message that look, my battery is very low, but just I wanted to ask something. And they established communication with the people outside the cave, and who were saved even after the landslide. And after that radio communication, they asked some questions. The first question was that we have limited food, can we have more food? The answer was no. We are trying, we are sending everything possible to save you, but it will take time. So, the next question was that suppose we have no food, can we starve for another 30 days, because it will take lot of time? The answer was you cannot be living for another 30 days. So, the next question was that how long can we survive without any food? The answer was maximum 7 to 8 days, and that was the 13th, 14th, 15th day. So, after 15th day, the next 8 days they could survive, but after that one by one maybe that they will lose their lives. Thereafter, another question was that suppose if we have that moment of life that someone will starve and death will be there, can we prevent it by killing someone else and eating the flesh of that person, and then we can survive for some more time? Can we do it? Medical practitioners, the jury judges, the religious people, they were all invited to answer this question. And the answer was that we can't answer it. How can you kill someone? to save your life? No one answered. But the medical people, they said that you can survive at least for a week, next 1 week or 10 days maximum. So, okay, thereafter the battery was lost, the battery was not there, radio communication was lost, and thereafter the person who asked this question to the outside world, that person said, okay friends, now we know the answer, how long can we survive? We are doing what? We are doing a toss, and by toss we will decide that if that situation comes, who will be killed first? And you know what? That the person himself was so fearful of tossing that he said, no, 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 I am withdrawing from this game. I will not do this, because this is just exercise where someone will be killed. So he said that no, no, I will not do it. Then what happened? The second person says in the group, second person says, no, how can it be right? You had said, you had established contact with the other members of the world, and now you say that you will withdraw. So he said, no, 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 I will toss. And what he did, he tossed the coin or the thing what he had, and thereafter who lost it? The person who had asked this question to the outside world. And the first opportunity to kill was that person who had asked the question. So everyone decided in that group, 4 other people, they decided that this person will be killed first, and they killed him, and they survived for another 7 days. After 7 days, due to the humongous efforts made by the people outside the cave, many people entered into the cave, and what happened, that they were saved, their lives were saved. Now once they came outside the cave, they were arrested by the police, and the prosecution started. The matter went to the court. The question before the court was whether these 4 persons can be sent to jail for killing one person. Was it a case of homicide, culpable homicide? And the law was very clear. The law was that whoever shall willfully take the life of another shall be punished by death, and there will be no exception to this statutory provision. So law was very clear that whoever shall willfully take the life, here life was willfully taken, and there is no exception. So as a lawyer, as a judge, what will you do? If you are a person who only knows that no, whatever law is there, I will have to administer that law, then the person cannot be saved. Those all 4 persons should be punished. But if you think that how can these people survive? It is the question of survival. It is the question of self-defense. It is the question of natural law. If you understand that nature is giving us the power to defend ourselves, then how can you do it? You will have to, in such situation, if that is the thing, then what is the other way out? Every person wants to save his life or her life, and if for doing that, this is not out of choice. This was because the question of survival was there. This was because the question of life was there, and in that case the normal laws would not be applicable. The normal law, and when this case, this is the situation which was described by Lon Fuller in a very different way. He has composed 5 court judges, and all those 5 court judges, they were discussing this matter in different ways. One judge was saying it is very difficult. You know, did politically organized society ever think that this kind of situation will prevail? If they would have thought about it, they must have made some exceptions. So there was no such thing. And some other judge was saying that, oh, this is very difficult, because this cave, you may also imagine that this cave was beyond the territory of the nation itself, because you cannot go when there was a cave inside the cave. So, you should just think, and that was also imagination, that was because of natural law, that when you think that the cave which is not having any access point, no one can go inside it, then how can you say that you have jurisdiction over the people? So, it is a very interesting case. Students, if whenever you have time, you can look, you can go into this case, you can discuss this case, because this will open up different dimensions of discussion. Whether natural law should have been followed, whether legal positivism should have been followed, whether the social contract theory, because this was also a discussion made by one of the imagined judges, that one judge was saying that yes, look, the social contract, the initial social contract to form the government, that was that everyone's life should be saved. So, this was the agreement, and from that agreement every power is derived. So, initial agreement was that everyone's life would be saved by the government. Now, that is very important, and therefore, someone has saved the life to someone has killed someone to save one's own life, that is justifiable. So, justifying on the basis of self defense, on the basis of survival, that was not culpable. So, you see that this was an interesting example of the fact that there can be situations when there is no way out than to follow the natural law. So, this case is an important imagined case, although, but in real life also this may happen, and whenever these things happen, you will have to look beyond what is given in the law. And as a judge also, as a jurist also, as a member of the legal order, you have to sometimes go beyond the written law, and you have to think in the lines of natural law. Now, analysis of this Spencean explorer case, if you apply the Fuller's principles, then you will find that the law was clear that murder was illegal. It was general, it was promulgated, but you will find that the situation challenged the applicability of law. So, there was no possibility of compliance. If you further examine Spencean explorer case, you will find that there was difficulty in the legal clarification. It acknowledged the existing legal framework, the system was stable, but it highlighted the tension between upholding the law, congruence, and recognizing the extraordinary circumstances, which was about effectiveness. So, in one place what Lon Fuller did, that he said that there are 8 principles of legality, and then he himself challenged by saying that there may be some times when some of those principles of legality, those cannot be fully adhered to. What is the conclusion from the Spencean explorer case? That if it is viewed through Fuller's lens, this case tells us that legal principles can be both clear, but challenged by exceptional situations. That prompts us to consider the need for legal nuances while upholding core principles of justice. So, students, this is very interesting imagined case, but what was important, that the 8 principles of legality and what the challenges which are thrown in the real life of a person, that can sometimes need natural law, the help of natural law, that is very important. So, Lon Fuller's contribution in the field of natural law is important in this way. Now, let us try to understand 1 or 2 cases which are decided by our Supreme Court, so that we can learn that how natural law philosophy is relevant in the current times. The first case, the first example will be of Menka Gandhi's case. Menka Gandhi versus Union of India, which was decided by the Supreme Court in 1978, that case was an example that when the passport was to be impounded by the passport authorities, you know what happened in Menka Gandhi case? In Menka Gandhi's passport was impounded by the passport authorities. And why was it impounded? Menka Gandhi's passport was impounded because she was about to leave the country, and at that moment of time Mrs. Gandhi was the Prime Minister. And Mrs. Gandhi had the apprehension that when Menka will go abroad, she will talk just nonsense relating to the governance of our country, and therefore there was the impression that she instructed the passport officials to impound the passport of Menka Gandhi. And so the question was whether the law allowed this. What was the law? Law was the Passport Act of 1967. The authorities looked at the act, the provisions of the act. The Passport Act clearly said that passport of any citizen can be impounded by the passport officials under section 10 of the act. Then the question was, can it be impounded? The answer was yes, it can be impounded if it is in the public interest. Now, the public interest, in the last lecture we had already said that Roscoe-Poundian theory of social interest, public interest. So, in this case passport officials impounded the passport of Menka Gandhi on the premise that her going abroad was not in the public interest. Now, Menka Gandhi challenged this action of the government and of the passport officials in the Supreme Court. In the Supreme Court, the contention of Menka Gandhi was that my passport was not impounded in the way in which it was a fair decision. Now, fairness was the main contention. Fairness was the main plea of Menka Gandhi. What she said, that her passport could have been impounded at least after she was heard by the passport officials. How can just they imagine that I am going abroad to criticize the government? I was not going for that purpose. So, what she said, that okay, even then, even if suppose you think that I am going with that view, but still at least I should have been given a hearing. You impounded, you took away my right to go abroad, you took away my right to liberty, and that too without hearing me. So, this was the contention of Menka Gandhi, but the government was saying that no, this is completely legal, the law was there, the Passport Act authorized the passport officials to impound the passport. So, it was completely legal, there was nothing problematic. But Menka Gandhi's contention was very serious. What she said, that law is not just because it is made by the parliament, but it should also be fair. And what is the principle of fairness? The principle of fairness is that one must be heard. If the judgment, if there is going to be a decision which is against the fundamental rights of that citizen, then at least there must be hearing of that situation. So, Menka Gandhi contended that this is against the constitutional provision, this is against the fundamental rights of a citizen, of say fundamental right of liberty, and therefore, that should be laid aside. This kind of Passport Act provision, that should be struck down. So, the court accepted Menka Gandhi's contention. You see that natural law school, this was one of the example in which fairness in law, that was accepted by the court. The court said that law should be also fair, and how a law should be fair? It should not only be a law passed by parliament, but law should be fair in the sense that you must give hearing. If a law does not permit hearing and law permits just taking action against the citizen violating the fundamental rights, that is not allowed, that is not a fair law. So, this is one of the examples of our own judiciary which favored natural law principles in interpreting the laws. The next example will be of ADM Jabalpur versus Shivkant Shukla. In ADM Jabalpur case, which is a case after emergency, when the national emergency was declared on the grounds of internal disturbance in 1975. After that, you might have heard that many people, they were arrested, they were detained, and every jail of the country that was filled with the people, the leaders, the people who protested, and those people were detained in the jail. Now, ADM Jabalpur was representing the state, and Shivkant Shukla was the victim of the powers of the state. What had happened that when the emergency was imposed, all the fundamental rights of the citizens, those were taken away. Now, when all the fundamental rights would be taken away, then the government can do whatever it likes to do. You can detain, because otherwise constitution had given guarantee against arbitrary detention. But when all the fundamental rights are gone, then how can you be saved? So, all the people, many people who protested against the government, they were put in jail. When Shivkant Shukla went to the Supreme Court, although he filed a petition in the High Court, but then there were so many petitions before different high courts of the country, all those petitions were bunched together, and finally a hearing was given by the Supreme Court. Now, in the Supreme Court, one of the contention which was given by Shivkant Shukla was that, look, Lordship, the law which said that anyone can be put in jail, that law is not right, because human rights are very important. He gave the example of Universal Declaration of Human Rights. He said that UDHR is very important. India gave its support to UDHR. India was a member when this UDHR was adopted by the UN. Then how can we say, and in UDHR there is a principle that even during the time of national emergency, the fundamental rights which are very important, they should not be taken away. Shivkant Shukla was saying that, Lordships, kindly consider UDHR. Although we have the law in our fundamental law, the constitution, that fundamental rights can be taken away. But then why India supported UDHR, which is about human rights, which is about human rights protection? Then the judges, the majority judges in that case, they supported the state, they did not support Shivkant Shukla. There was only one judge whose name was Justice H.R. Khanna. He only supported the contention of Shivkant Shukla. He said, even though I am alone, I am not in the majority side, but I will definitely say that there is nothing called morality, because other judges were saying, no, this is just moral. Morality will have no place in the legal system. The law is very clear, the positive law is very clear. But Justice H.R. Khanna was saying that UDHR, the human rights, are not merely the principles of morality. Human rights are natural laws and they should not be taken away. The human right to life and liberty, that should not be taken away even during the times of emergency. Students, that was the time when in ADM Jabalpur versus Shivkant Shukla, Justice H.R. Khanna was in minority. He was alone. He was a solitary person, solitary reaper. You might have heard the story of solitary reaper. But just within 2-3 years, the whole course was changed, and you see what, that the majority judgment was overruled by a constitutional amendment, and now even when the emergency will be declared, Article 21 and Article 20 rights, fundamental rights, cannot be taken away. So, students, what I wanted to tell you, that in our country also the natural law principles have been implemented by our judiciary, and when sometimes judiciary could not do it and it just followed the principle of legality, then sometimes executive, sometimes legislature, they chipped in and they accepted the natural law. So, students, we try to understand the natural law school of jurisprudence today and what was the contribution of Lon Fuller in this field, and I hope that you might have understood natural law principle, the contributions of Lon Fuller, and what were the contributions in our country by the judiciary and by the union legislature and the executive. I hope you must have understood these things. Thank you so much. Have a great time. We will meet next time. Thank you.
Hi, my name is Gillette Sam and I teach sociology at IIT Kanpur. Today I want to tell you a little bit about what sociology is. In order to go ahead and study sociology, one of the things you need to develop is a sociological way of thinking. Now, this capacity to think in a sociological manner was termed as the sociological imagination by an American sociologist called C. Wright Mills in 1959. He argued that in order to think in a sociological manner, you should be able to have two different skill sets. The first skill set would require you to have the capacity to think beyond the problems that individuals face. So, if you encounter a problem that some one individual is facing, you should be able to connect it to a broader public problem. Mills gave the example of people in his neighborhood. He says if there is one person who is unemployed in the neighborhood, that seems to be an individual problem, but as a sociologist you're expected to dig around a little. So you come across a couple of other people in your neighborhood who are also unemployed. That indicates to you that rather than being a specific problem, there is a larger public issue at hand. So as a sociologist, you're supposed to look at individual problems and see how they are connected to broader public issues. The second capacity that you're expected to develop as a sociologist is the capacity to link an individual's biography with history. Historical thought may not come to you as the first thing that's connected to sociology, but it plays a pretty important role in the field. So Mills argues that rather than looking at a problem in the here and now, it's important to trace that long historical trajectory that may be connected to this individual problem. Let me give you an example from India, right? Let's say you look at the women in your family. Let's see at what age do they get married. So you may see that your sibling is getting married at the age of 25. Go back one generation. At what age did your mother get married? You may find that she got married a little younger, let's say 21. Go back another generation. At what age did your grandmother get married? You may find that she got married even younger, 18 or possibly even younger than that. So this capacity to see how the history of a family then influences the age at which your sibling got married, that is the capacity to bridge the biography of a person, or rather by biography we can also think of the biography of a particular problem with history? What has happened in the past? How is that connected to this individual or this problem in the present? Thank you.